Welcome to the Louisville Probate Law Podcast with attorney Scott Scheynost. He'll provide helpful information about wills, power of attorney documents, and other issues related to probate law in Kentucky. These tips and easy-to-understand conversations can save you time, money, and stress related to a topic each of us will eventually have to face. Let's join Scott for today's episode. Friends, welcome back to this episode. We're in the studio with attorney Scott Scheynost. Scott, how are you, guy?
Doing pretty good, Jim. How are you?
Pretty good, man. Hey, today is a pretty cool topic, and this is one thing that I think confuses a lot of people, but we're going to talk about what to include in or what to exclude from your will.
Yeah, I think each attorney may even have a different view on what to include and exclude, and it's kind of a balancing act of a couple of things, the nature of the asset and also how much money you want to spend. And first of all, let me just kind of explain my own personal view on this. I like to keep a will as simple as possible. I like to give heirs a certain share of an estate and, let them decide, how that's going to be distributed as far as what's equal, because certain assets may mean more to them than other assets to other heirs. And I like to give the executor a lot of discretion in how to distribute stuff. That being said, everybody's situation is a little bit different. And you probably know your situation better than anybody else, and you know your heirs and what they want and don't want probably better than anybody else. But the more things you include in a will, generally the more the cost of the will too. And again, let me get back to my philosophy. I like to keep it simple. We have a simple will package that we do for folks for a couple. It's $250. That's a simple package. That's basically where you're naming some heirs. You give everything to your spouse, and then you've got a couple children. They get everything in equal shares. That's pretty much the simple package, and that actually saves money in probate. You name an executor; they can serve without bond. We get things opened up and moved on, and it actually ends up saving the estate money, believe it or not. And you can make it as complicated as you want. You can list all your assets. You can list requirements for people to get it. But every time you do that, you're going outside of this simple package, and it's a balancing act. Do I really want to spend a couple $100 more to make sure that cousin Bob gets my, 1965 Henry rifle, for instance, or going through a list of assets. So it's a balancing act. I prefer the simple way. My experience, and this is probably true in my house, my stuff means more to me than anybody else. And, if you had to go out and rebuy all the junk in our house, we'd spend a whole lot of money. But when it comes to actually people coming in and taking it and distributing it, a lot of times the stuff in our house, the underwear, the utensils and stuff like that, has a lot less value to other people than it does to us. So it's kind of hard to accept that sometimes because we paid for it and we've lived with it. It was real important. We made a lot of decisions to buy it. But when it comes to distributing assets, usually there's going to be certain things that have a whole lot of value. The value of the house, things that are titled, cars, bank accounts, stuff like that. And some people own collections. They own art collections. They own gun collections. They own doll collections. Some of those things, comic book collections, they can have
baseball
a whole lot
card
of
collections.
Baseball cards, yeah. I've been amazed at some of the stuff that people collect that has value. And a lot of that stuff is stuff that you want to name in a will, you want to give to somebody. But a lot of other stuff that might mean a whole lot to us may not mean a whole lot as far as value to somebody else, especially older furniture. My wife likes china. She's got several collections of china. It means a whole lot to her, but I don't know what my daughter's going to do with 4 sets of china. I don't know if she'll ever even use one set in her life. So it means a whole lot to my wife, though, and she's going to make sure my daughter gets this. So everybody's a little bit different, but I like to keep it as simple as possible. First of all, sometimes it's hard to get people to do a will. If we can make a will simple, they can get it done fast, and we can move on, and we can save some trouble for the estates later on down the road. Now, if you have a whole lot of assets, if you're real adamant about stuff, if you want certain things that have high value to go to certain individuals, then you can add that in the will, but it'll also increase the cost of the will. We're going outside of the simple will and increasing the hourly cost, I guess, to do that.
Well, and to be clear, you mentioned a simple will package, which is at the time of this recording anyway, is $250, but that includes some other documents. I mean, that includes your power of attorneys and your healthcare surrogates and all that other stuff. I don't want people to think, wow, it's a $250 will. No, there's a whole bunch of other stuff that goes along with it. But
yeah, we actually give you 3 documents for that too. Yeah, the basics of the probate. Yeah.
So if I have some specific personal items, you mentioned an old Henry rifle that I want to give to so and so.
Right.
You also recommend including some very specific language in there, which may actually protect the estate or the executor, right?
Yeah. Well, sometimes there's a question if the decedent leaves property to someone, and let's say that property they owned at the time they created the will, but they sold it later on, and then after they sold it, they died.
Never updating the will.
Yeah. Does the executor now have to go out and buy that property and give it to the person named in the will? And I put language in my will that if they don't own that asset at the time they passed, and that we call it a bequest, it lapses, which means it doesn't need to be enforced. And that's to prevent the executor from having to go out, if there's a possibility of this occur, that they would have to go out and buy that asset from the estate and give it to that particular heir. And my view on it is if you sold it or got rid of it before you died, then you really didn't want that person to get it. And we try to explain that to everybody, and that way it creates less confusion for the executor and the estate and trying to get things taken care of. So when we do put what we call a specific bequest, where you're giving Cousin Bob that 1865 Henry rifle, we also put a phrase in there too, if I do not own this property on my passing, that this specific bequest will lapse and it doesn't have to be enforced. So that's the purpose behind that, and a lot of the wills that we do is to make sure that there's not any confusion about what has to be done with the executor as far as buying assets.
But you do recommend putting titled assets. Do you want to define kind of what a titled asset is?
Well,
you recommend putting that in the will.
It depends on the title too. Again, I like to keep it as simple as possible. I like to give everybody just certain shares. Now, if you have certain assets that are titled, let's say you have a car, you may own a 1965 Mustang convertible when you create the will, but by the time you pass away, that may have been sold and replaced with a 2006 Malibu. Okay, so if you leave a specific car that's titled in the will, that gets back to the specific bequest. If you leave a car, well, that means, again, does that person get a car when you die? So you want to add that phrase. I like just giving people shares. If you have a titled asset, then unless it's something you specifically want to get to somebody you count on holding on to, like a collectible car. If I had a 65 Mustang, I'd hold on to that, okay? And that would be something I want my son to get. So if you've got a specific titled asset like that you want a specific person to get and you're going to hold on to it, I would put that in the will. If it's something that's titled that changes over time, the make, brand, whatever, we go through cars as we get older, that may not be something that you want to specifically put in there.
Well, what I found interesting, and this came up in our prep for this episode, is you've got a philosophy about keeping it simple, but there's another important reason, is because the will becomes public record, right?
Yeah.
What's the downside to that?
Well, I've seen some publications that say, you put passwords and bank accounts and things like that in the wills. But when you pass away, in Jefferson County, it literally becomes public record and it's published on the internet. And you can get on the internet and see the contents of anybody's will that's passed away in Jefferson County over the last 30, 40 years. So if you put that information in there, I couldn't see putting a password in there unless you're going to change it as soon as somebody passes away before the will's probated. If you put some of that information in there, then, with all the mining people do trying to find public information on folks, I think you're just inviting trouble a lot of times. I guess bank accounts, you can redact some of the information, but even knowing what bank to look at sometimes might cause problems to me if somebody's trying to break into something. So I don't like putting personal information in these documents because they become public records. And not only public records where you can go down to the clerk's office and pull it out and look at it, but literally on the internet. I can pull up my phone and see, the last will we filed in probate court and see what it says. So that just scares me to death to know all that kind of personal information is out there. I would actually try to redact any kind of personal information from a will. They also, in Kentucky, you can file a will before you pass away. And I think the intent was to make sure that, your house didn't burn down with a will in it, so you could file it at the clerk's office and the county clerk. But once you do that again, that's still public record.
Well, and that brings a question. I mean, should I actually file a will with the at the courthouse? And you've often said, no, don't do that. But that begs the question, okay, who should I give it to and where should it be kept?
Yeah, I don't like filing the will at the courthouse. Number one, it's public record. Everybody can see your business. Number two, if you decide to change your will later on, you need to make sure that change is also filed at the clerk's office, or you risk the original will being the one everybody accepts. So it just creates a lot of problems to me if you file the will before you pass away. What I recommend to folks is they put it into a lockbox. If you're a guy, I'm going to say put it in your gun safe. Seems like everybody's got a gun safe as a guy anymore. Someplace that if there's a fire, it's not going to get burned up. You can go to Staples and for $20 get a lockbox. It's almost fireproof, or fireproof enough. Unless you're going to have a nuclear bomb go off, it'll probably be okay. I don't like putting the will into a safe deposit box.
That really surprises me, but I understand. I think I understand why.
Yeah, well, a lot of times a bank will freeze all your accounts when you die. If they learn that you've passed, they'll freeze your accounts, your bank accounts, and that includes the lockbox. Now, there's ways to get into a safe deposit box at a bank to see if there's a will. You've got to jump through some hoops to get that sometimes with the bank. Sometimes you have to get me involved in it. It's just a whole lot easier if you can just keep that will in a lockbox. And what we do is we give folks a will with an envelope, and we can have the envelope sealed. And that way, you can tell your kids where the will is. You don't have to tell them what's in the will if you don't want to. And if it's sealed, they don't get access to it unless they're going to break the seal, like any other envelope. But that way you can tell them where it's at. If something happens to you, they can find it and use it, and then they can open it up then. But in the meantime, it's sealed. If you want to make changes to it, you can make changes without them knowing about it. That's what I prefer. It's easier to get to. A lot of times people are working on this on the weekends when the bank's closed. If you've got a lockbox, they can pull it out. They can make copies of it if they have to and give it to other heirs. We've talked about that before. A will becomes a public record, so you might as well let everybody know what it says if you have to. Now, if it's in the bank, you got to make arrangements with the bank. Which bank?
Well, what I find interesting, we've talked about this in really the previous episode number 4, and also I believe in episode number 3, because the will assigns the executor or appoints the executor. You've got some other steps, but it says this is going to be the executor. If you don't have the will, the bank's going to be a little leery about saying, "Okay, Joe, you just want to get into somebody else's lockbox or safety security box."
Again, there's hoops to jump through to get it, and it can be done, but it's just a little bit more cumbersome to do it that way.
Yeah, I can see a lot of problems there and delays.
And I've seen banks where people forgot they had safe deposit boxes, and what's the bank going to do with it then? I've had folks lose their keys to the safe deposit box, and they got to get it drilled out. Well, if you're not the executor, if you're not the decedent who has the account, that can be trouble too. So to me, it's just a little bit more cumbersome with a lockbox. Again, it's just really easy. For what you would pay for a lockbox, you can get a fire safe from Staples. And
you got to share that combination though with somebody.
Well, or a key or whatever. Yeah. But again, that can be done. To me, that's just so much easier. And again, the gun safe, almost every guy seems like I deal with has got a gun safe.
Yeah.
Some of them, a couple of them.
Yeah.
And they're usually fireproof. So that's a good place to put it too. Okay.
Of course, the issue being, does anybody have access to the gun safe?
Well,
that's. But again, it's a balance, right?
Most guys are going to take care of that. Yeah, they're the only people they know are going to be able to get into that stuff. Yeah,
that makes sense. Well, let's jump over to the other side of the equation, which we talked about stuff to include, but let's talk about stuff to exclude, stuff you don't actually have to put into your will.
Yeah, what I find is a lot of people assume certain assets are going to be part of their estate, and they're wrong, and this is why. Certain assets that we own jointly, usually with a spouse. A lot of people own their house jointly, and usually that means when one person passes away, it becomes the survivors. And that doesn't go through probate because as a survivor now owns it. There's really not anything else to do.
But there are some very specific phrases that have to be on that deed, correct?
Correct. And it usually has to say joint ownership with survivor or something to that effect.
Right of survivorship.
Yeah. And a lot of things I think we assume are jointly owned, like furniture and stuff like that in the house. But as far as the property, and I'll have this come up a lot, have a couple that passes away, and it's always the guy that passes first. The guy passes first, and the surviving female spouse is asking me what I need to do to put the house in my name. Well, you already own it. There's really not anything else to do because it's jointly owned. And if you ever sell it, then you do an affidavit showing where somebody's passed, and that's why they're not signing the deed to transfer it to somebody. But there's usually not any reason to do that right now. And I generally tell them don't worry about it until you get ready to sell the house. And it's hard for a lot of folks to understand that there's not anything to do, but it's already been done. It's already been set up jointly. So as far as your house, unless you're the sole owner, if you own it jointly, that's not usually part of your estate. Now, when you're the surviving spouse after your first spouse has passed away and you're the one that's left, and that becomes part of your estate. A lot of times we don't know which spouse is going to pass away first, and if both people, both couple, everybody in the marriage wants a certain person to get the property, then we can put that in both wills, which can be changed too after somebody dies.
Right.
But we can handle it that way. But the joint ownership, I really think a lot of people just don't understand how that works. When one spouse passes away, it automatically becomes the other spouse. And in almost every house I've seen for a couple in Jefferson County has been jointly owned.
Okay.
And I think the real estate attorneys set it up that way without even being asked. And if you ask people, that's probably how they wanted it. But almost every house I've ever seen purchased in Jefferson County with a couple that's married, it's been jointly owned property, and this applies to them. Now, there's a couple other assets that don't go through the estate that a lot of people think go through the estate. Commonly, I have people tell me they want their 401k plan, their retirement plan, their pension plan, their IRA, their life insurance to go to somebody. Well, that's usually already been taken care of. Usually those type of instruments, especially life insurance, have a beneficiary. And what happens are these companies have got a contract with you to give those assets, that money, to a specific beneficiary. And almost always when you first started to open up this account, you filled out a form, and you may have forgotten about it, where you named a beneficiary, especially with life insurance. And it's now that company's obligation to give that beneficiary the money they're due underneath that life insurance policy, or that 401k plan, or that pension plan, or that IRA.
And that passes outside of the will, that passes outside of the estate, it passes outside of probate.
Unless you name the estate as the beneficiary,
Yep.
which is usually not what you want to do, because it defeats a whole lot of purposes. Number one, it means it's going to have to go through probate, which slows down distributing it. Number two, it might be subject to creditors' claims, which most people don't want to have. Sometimes there's some tax consequences when you do it that way. So generally, you do not want to name the estate the beneficiary in any of those policies, because the whole purpose of a lot of these things is to get the asset to the person that you named as beneficiary as soon as possible, and you're slowing that process down. Secondly, you may have other things that might be something you want to avoid, tax consequences and other things like that if you do that. So a lot of people don't understand, you've already named who's going to get that property. It's going to pass outside of the estate. And people ask me, well, who's going to get it? Well, it depends on the policy. It depends on who you have, the company. It depends on what you signed before. My dad's an insurance agent. They've probably got 1,000 different types of life insurance policies, and they probably all have different beneficiary clauses to them. So I hate to tell people this, but you've got to look at the actual policy, and you've got to read who you've named as beneficiary, and you've got to read what happens if that beneficiary dies before you, who's going to get it. There's usually a contingent beneficiary. What happens if that contingent beneficiary has passed away? Well, again, you've got to read the policy. That might be when it goes to the estate. But you've got to read each document that pertains to this, for each life insurance policy, for each 401k plan you've got, for each pension plan you've got, for each IRA you've got. Sometimes people can set up what are called POD accounts at the bank, which are payable on death.
Yeah, I wanted to ask you about that. Can you kind of describe, because again, like the house, if the house is jointly owned, passes outside. If the bank account has Bill and Mary's name on it, it passes outside, because again, that's jointly owned. Or a car that's titled in both names, right?
Right. You can jointly own a bank account, just like you can your house, which means when one person passes away, it can go to the survivor. And that doesn't have to be with a spouse. I see this set up a lot of times where an elderly person might name one of their kids as the joint owner of the account. And I think the banks do that just to make sure that if the kid pulls money out of it, nobody can say that the bank didn't oversee this properly, because the kid's an owner. That's now their money when this happens. I question sometimes that's what the true intent of the elderly person is, but anyhow, that's how it's set up, and without some real strong evidence to the contrary, that's awfully hard to defeat that presumption that this is jointly owned. So when you have a joint bank account, and somebody else is on the account, and one of the people dies, it becomes the survivors. That's not part of the estate. A lot of times, grandma may put all her money, $100,000 in a bank account, and named, a niece to be the joint owner. Well, that now becomes the niece's property.
Yeah.
Without some real strong, clear evidence to the contrary, that's not part of the estate. That's outside of the estate.
So if I didn't want to risk my niece going in and siphoning off that account while I'm still around and may still need access to that money, you have what you'd mentioned was a payable on death account. Let's come back
Correct.
to that.
Yeah. A joint account allows somebody to also write checks, which is what a lot of people want to do. A payable on death account is still in the name of the person that created the account. They're the only person that can get into it. They're the only person that can write checks from it. They're the only person that can handle that property. But when they pass, it goes to somebody they've designated, payable on death, POD. So it's a little bit like a life insurance policy where you have a beneficiary. And it passes outside of the estate when it happens. But what I like about it is before you pass away, you're the only person that has access to it. It's not joint ownership. Nobody can get into the account but you. If you want to clean out the account and go to a different bank, you can do that. You don't have to have anybody else sign off on it like you would if you had to sell your house. So with a payable on death account, that's still your account until you pass away. And then when you pass away, it goes to the beneficiary. That's the specific account that you have to ask the bank account. I'm not sure if all the banks do that. It's permitted in the state of Kentucky. I've seen it a lot more here recently than before, but I think the banks just prefer to set them up as jointly owned accounts because people want to write checks on them. They usually want to, the elderly person usually wants to name somebody else that can write checks for them besides just get the money.
Well, at the same time, that the bank's also got to track down that heir or that person and try to figure out where they are so they can transfer the money to them.
Yeah,
or the account to them.
Yeah, it's a PO. Yeah, and what's interesting if you can't find them, it actually goes to the state of Kentucky, but that's another story.
Oh, okay, okay. So you had mentioned this earlier on it, pretty much in the beginning was about passwords because a lot of people think, well, I need to have people with access to my Gmail account, access to this account, access to that account, whatever. But as you said earlier, that could become public record and probably not a good thing to include in your will.
I wouldn't include it in the will. There's probably other ways to get around that. Digital vaults, I think, are becoming a little bit more popular where if something happens to you, then you contract with an outside company to give this information to someone else.
If you have a little lockbox, you can write it all down, put it in the lockbox. Here's my Gmail account. Here's this account. Here's this.
Yeah.
But if you ever update your password, you got to go back and update your little slip of paper.
That's true, and you also have to limit access to that. So passwords are just kind of a weird animal, and that's constantly evolving, and it'll be interesting to see what happens with that here in the next couple of years, because almost everything's been done over the internet anymore. Banking accounts and paying bills and stuff like that. So it'll be interesting. I got a feeling there's going to be some statutes and regulations that come up over that here in the next couple of years because we're just moving that way with our economy.
Yeah, I still like the idea of let me go to paper. I'm going to write down this account number, this bank, and here's the password. But I'm going to put it in that lockbox or that safe, so that not everybody has access until they need access to it. Scott, I'm going to throw you a curveball here, but it's come up before, and I believe we've talked about it, but I'm going to come back to things to include.
Sure.
If I have pets and I want to take care of my pets, or I want somebody to take care of my pets when I'm gone, should I include those kinds of instructions and maybe some funds in my will?
It doesn't hurt. It can't hurt anything. And, some pets, especially with my wife, are probably more important than the people she knows. And it's important for people to make sure that their pet's taken care of after they pass. The lady that used to own Liana Hemsley, I think, she gave a couple $1 million for one of her dogs to be taken care of after she passed away. So you can give your pet, it's considered property in Kentucky, to somebody as an asset. You can also give that person money to take care of the pet. If you want to make it real complicated, you can set up a trust fund almost for the pet to take care of it while it's alive. But it can be as simple as giving the pet to somebody. I can't see somebody that got a pet from a person that died not taking care of it.
You might want to have that conversation in advance.
Exactly.
And find out,
That's
would you
something-
be willing?
Yeah,
You know,
and somebody does not have to take the bequest if they don't want to. So, it depends on the person receiving it. It depends on the pet. Generally, unfortunately, we outlive our pets. So, you may not have this pet when you pass away, and that needs to be considered in all this too. But that can be taken care of in a will, and that's becoming almost like children to a lot of people. And again, I think there probably might be some stuff happening with the legislature with that and how that's handled. But the way we think about pets in Kentucky is simply as property, and any kind of property can be left in a will. But if you want the property taken care of, then you may want to leave some additional assets or create some other ways to take care of that pet after you pass away.
No, that's fantastic. Scott, I love doing these episodes with you because I learn things as we go, whether it's in the prep or in the actual discussion. And I want to let friends know that if you like this type of information, first of all, I'd encourage you to share it. But where can you find it? Well, the easiest place to go is to LouisvilleProbateLaw.com. And you'll be able to find all of those episodes on the podcast page. If you've got your iPhone with you or your Android phone and you just want to go out and can I find it on Spotify? Yes, you can find it on iHeartRadio, Amazon Music. You can find it on Apple Podcasts, Google Podcasts, all over the place. But the easiest place, and also that will make it so simple for you to link through and find out other information about Scott, is on LouisvilleProbateLaw.com. Scott, if somebody wants to get a hold of you and says, you know what, I do need to update my will, or I need to draft a will, or I need to bring mom in and have you talk to mom or dad about their situation, what's the easiest way for them to get a hold of you?
The easiest way is to call us on the phone, which is 502-937-5287. You can also contact us through the website. There's a contact form on the website to do that with. But that's usually the easiest way is call us. Again, for most people, I think the simple will package that we do for an individual, $250, $475 for a couple. Again, this is Simple Wills in 2023. I think that's probably how most people would go, especially if you don't have a will. If you don't have a will, at least start with a simple package, and we can get more detailed later on. Not everybody's situation is the same, and it's a balancing act between the assets you own, the money you want to spend. But for the will package, where you get a will, power of attorney, and living will directive, those cover the main things that people need to get going in case something happens to them. And I think that's a very fair price for the 3 documents you get. The one other thing I guess we hadn't talked about in all this is if you own a small business. A small business can have different types of ownership. It can be a sole proprietorship, it could be a partnership, it can be a S corporation, an LLC, and there's all kinds of varying degrees of small businesses, from just a sole proprietor to people having several hundred employees. So if you've got a small business, the bigger the business, the more you need to sit down and look at this. Who's going to, number one, receive the property in case something happens to you? Number two, how's the business, if it's not set up properly, how's it going to be run if something happens to you? If you've got business accounts in your name and you die, who's going to write paychecks? You need power of attorneys for that. You need, those are effective while you're alive, but you need to talk to the bank and have people designated to take care of that for you in case something happens. But your small business is not only important to you, but the people that work for you. And you need to consider their needs too if something were to happen to you. Number one, how are people going to get paid if something were to happen to you? Number two, is a small business going to go on? There's all kinds of different ways to look at that and handle that. And that's something you probably need to sit down and talk to an attorney or an accountant about, to make sure that they understand the kind of business that you have, what needs to be done as far as the assets after you pass away, how the business remains an ongoing entity after you pass away,
or how the assets get dispersed,
or how the assets
and the
get
debts get
dispersed,
handled
yeah.
if it's not going to continue.
And we could probably spend 4 or 5 podcasts on this, because a lot of it depends on how you've got the small business set up and whether or not you have an operating agreement or some other documents that say it's going to be bought out by a partner. But that's another thing too. That's a whole separate animal. And if you've got a small business, you need to consider how that's running right now, how it's set up, and what's going to happen with that in case something happens to you.
Sounds good. Hey, Scott, as always, thank you very much for your time. Thanks for your advice. Thanks for the perspectives that you share about this. And this is important stuff. When you're dealing with wills and putting all this stuff together, a lot of people get a little squeamish, but it sure does make it easier when you've taken the time to put your wishes down on paper and gotten that properly executed, so that it's ready to go. And Scott, that's things that you've done to help people for the last 30 plus years out there on Dixie Highway. And I really, really appreciate the knowledge you bring to these conversations.
We do a whole lot of wills. I enjoy doing them. Almost everybody goes, after they're done with them.
Yeah.
Because they've been wanting to do it for 10 or 12 years. So I enjoy it personally, and we're happy to talk to you about it if you've got any questions about it.
Outstanding. Scott, we'll talk to you in a couple of weeks. Take care. Bye-bye.
Thank you for listening to this episode of the Louisville Probate Law Podcast with attorney Scott Scheynost. The content provided is for informational purposes only and does not establish an attorney-client relationship. For additional information, visit louisvilleprobatelaw.com.